This is Becki Young from Grossman Young and Hammond. Today is Thursday, April 9th. Today I'd like to talk about what happens if you come to the U.S. temporarily as a visitor, a student, maybe a J-1 trainee, or even on a work visa, and you get stuck here. You can't find a flight home, you don't feel safe returning to your home country. First of all, a disclaimer, this video is for informational purposes only, and if you do need specific legal advice, you should consult an immigration attorney. This video is specifically going to cover the topic of immediate relatives of U.S. citizens, that is, spouses, parents of a U.S. citizen over the age of 21, or unmarried children of U.S. citizens who are themselves under the age of 21. So all of those individuals that I just mentioned are eligible to immigrate to the U.S. at any time based on their relationship to the U.S. citizen. But there's a catch. You can't enter the US on a temporary visa and then turn around and apply for a green card. The reason is one of intent. When you enter the US on a temporary visa, you're expressing an intent to return to your home country. If you then do something inconsistent with that intent, you could be found to have committed fraud, which is a very serious immigration violation. I'd like to talk about the situation where the immediate relative entered the US with the true intent to return home. They had a round trip ticket. They hadn't given up their home. They hadn't given up their job in their home country, but now they're stuck here. The US government has a rule to address this situation, and it's called the 90-day rule. The rule says that if you enter the US in a temporary status and you do something inconsistent with that status within 90 days, such as marrying a US citizen and taking up residence in the US, there's a presumption that you committed fraud. The 90-day rule is a State Department rule, so it's mostly relevant for someone who's processing a visa abroad and not for someone who might want to apply for a green card in the US. US green card applications are the realm of USCIS, and USCIS does specifically have language stating that the State Department's 90-day rule is not binding on them, but in reality, USCIS officers do sometimes consider it in their decisions. So basically, if you entered the US more than 90 days ago, and at the time of entry, you had the intent to return home, and now your intent has changed. You want to immigrate in the immediate relative category, the 90-day rule should not impact you. But if you entered the US less than 90 days ago, you should be very careful about taking any action, such as getting married to a US citizen or filing a request to immigrate in the immediate relative category until 90 days have passed. If you were admitted for more than 90 days to begin with, for example, you came on a B1, B2 visa, you were admitted for 6 months, or you came as a student, for example, this is not so hard to do. But if you came as a visitor under the visa waiver, otherwise known as ESTA, you only have been admitted for 90 days, and then your situation becomes more complicated. Because the possibility of a fraud finding is a serious risk, if you did enter on a temporary visa with temporary intent, and your plans have changed, you're thinking about immigrating in the immediate relative category, we urge you to consult with a qualified immigration attorney.